though an adjournment is given, comma, the matter is directed to be listed on
7th of May.
7th.
That's a difficult.
What about 2nd of May?
Oh, 7th will not be there because 7th will be holiday in Guwahati.
Oh, second.
Election.
Second of May.
Second, May. Second. Yes.
2 May. 2/5.
May not be possible. Can it be on 9th?
Why second? What is the problem? We'll accommodate you.
Uh,
You will not be here. Okay, 9th of May.
May I please? Doctor, we have filed one writ petition yesterday, my lord. Is certain in nature.
Motion.
Most.
When do you want?
I want tomorrow.
Okay.
May I please, your lordship?
Bench 5, Mr. Barber.
Yes, my lord.
Yes.
But I beg to mention item number 12. With the consent of the petitioner. The
Yes.
matter may be taken up after.
Inform the other side.
Yes, ma'am.
Mr. Kadir, there for the private respondent informed.
Yes.
What is your name?
A.K. Hanna.
AK?
Hanna.
Hannan. You're with Mr. Bonik?
No.
Item number?
I'm 12. I'm appearing on behalf of MJ Khan.
Oh, you're for the respondent?
Yes, ma'am.
Taking the consent of the petitioner?
Yes.
Okay, okay. Sri A.K. Hannan, learned counsel for the respondent, praise for an adjournment. No, don't write this. On the prayer of Sri A.K. Hannan, learned counsel for the respondent number? Private respondent.
Private.
Matter is adjourned to be listed after the Bihu vacation. Yes.
Public.
May I please, lordship? Lordship, I have filed a writ petition on 4th April, lordship. And this is an eviction matter, lord. Land acquisition matter.
Motion
Yes, sir.
tomorrow.
Yes. Apply.
Hello, I picked the mention for listing, my lord. Motion on tomorrow.
Filed or not?
File.
Bench 5 matter.
Yes, that is.
Okay,
Well, a similar prayer.
okay.
Lordship for listing the matter and side orders matter.
Motion or orders? When?
After petition.
Oh, matter of which year?
But my lord, in this year.
Sorry. No. Yes, madam.
It is the seller, the purchase I picked the item number 16 for
1616. You're for whom?
G Baudelaire.
Oh, he's for the petitioner. Okay. When do you want, madam, after the Bihu holidays? On a prayer made on behalf of the applicant petitioner. List after the Bihu holidays. Same about WPC. Yes. Yes,
Ma'am,
sorry.
Lordship, I beg to mention item number 20, my lord, admission supplementary matter.
20.
20, my lord, matter is very urgent, my lord is not seeing the second half, my lord. So maybe, my lord, immediately taken up after the motion, my lord, considering the urgency of the matter, my lord.
What is the urgency?
Urgency, my lord, my lord, the division bench is direct to case here the matter, my lord, date the basis, my lord, considering the urgency because 19 is the last date for nomination. He is the candidate for the Cooperative Constitution matter. Only tomorrow is left out, my lord, working days, the working day.
Oh.
My lord, thereafter, no.
No, we'll definitely try, but second half this court, because of some other assignment, the tribunal is there, Manipur tribunal.
My lord, I am aware of that, my lord. That immediately after motion, my lord, there is 9 motion.
How long will you take?
My
Is
lord,
there a direction for disposal of the matter?
my lord. See, the division bench order is the.
How long will it take?
My lord.
How long will it take? How long will you take? You are for
My
the
lord,
petitioner.
Maybe, my lord, the day, my lord, may require, my lord.
What, till 1
And
o'clock?
then there will be the deliberation also from the, my lord, respondent side, my lord.
Okay, we will definitely try, but let the motions be over.
My lord. My lord.
But this is, there are, how many admissions are there above you?
My lord, above me, my lord, 14.
Not too much. Not too much, 4.
Maybe, my lord, if stuck in any admission matter, my lord.
1394. 1394. We will have it a matter after item number 12. It will be in order.
My
Item number? Not 14 is a matter 1873. His is 1394. Prior in point of time. We'll try.
Hello.
But kindly ensure that the other side
My lord,
is also here.
my lord, always there, my lord. It has to come, my lord.
Okay, okay.
May I put your- I pray for listing a press matter
Motion matter?
Yes.
When?
tomorrow.
Have you filed or not?
Yes.
Yes, okay.
No, there was an order, my lord, to list it along with the earlier writ petition, my lord.
Not listed?
Yes, my lord. 4598, my lord.
Of 2023?
That is pending. One writ petition was allowed, and thereafter second writ petition is further.
Do Harshri GN Sahavla learned senior counsel, who by referring to the order dated 28/3/2024 has submitted that there was a direction to list this matter along with WPC 4598/2023. However, it appears that the said direction has not been followed, full stop para. List this
26.
matter.
26, my lord, might come to happen.
Okay, Liz, as prayed for, list this matter on 26/4/2024 along with WPC 4598/2023 para. Let this order be brought to the notice of the Registrar Judicial.
Item number 3.5, I'm bringing my passport. Mr. Singh is on leg in another.
Who is your senior?
SK Singh, senior constable. Item number 3, 4, and 5.
Ask him to come because if he starts some other
After 5
matter,
minutes, Pratik.
Mr.
Yes, two
Biswa-
items.
okay. Two, you are there.
Yes, ma'am.
Okay, you can start by the time. If you want to start, you can start by the time Mr. Singh will join you. Yes, what is this? Madam, you are for the Revenue Department.
Yes. I the purpose your lordship is awaiting instructions. And in the other matters, your lordship, the affidavit of 6.5.
Mr. Biswas matter, your instructions are still awaited. Okay, is there any interim order protecting you?
Yes.
Okay. It depends on how you, if you want to press, you can press. It's for motion, we can issue notice at least.
Yes, ma'am.
Yes, what is the matter?
So this was regarding the
No, Mr. Biswas, what is the?
My lord, to construct the flyover at Mission Charlie, they have issued a notice that they will take over my land, my lord, and my building. But the only point is that, my lord, from the middle of the road, 52 feet they want to take away. Our submission is that it is 32 feet, no, cannot be 52 feet. Now they are to decide how they are saying that 52 feet they will take up.
No, what is the basis of your statement that it should be 32 feet?
Yes.
No, what is the basis?
No, my lord, it is the patta land we have purchased in the one cut of land.
We are not on that. You are saying that from the middle of the road, the width should be 32 feet. What is the basis of that?
Well, that I too do not know. But more,
No,
we have talked to Mandal. They
No,
said
you-
only 32 feet they will get. From middle of the road to my boundary. That is 32 feet. Cannot be 52 feet. They have measured 52 feet up to my building.
No, see, the land which they'll be acquiring is within their prerogative. Of
Uh,
course, it has to be
yes,
done
yes.
by following the due
But
process.
till
of law.
today, they have not acquired any land.
No acquisition proceeding has been
Yes,
taken.
no. Only they have measured, they said that up to this muster you have to demolish this.
Mr. Barua, what
My
is?
lord, in this regard, particularly his submission regarding 52, 60, whatever, this is the authority concerned, this who is a constructing agency
Yes.
will decide. Mr. Sushila said this case is clearly decided. They are the engineering authority, they have to decide.
No,
What is,
that is the reason.
that is the reason, my
No,
lord.
that is the reason we had put to Mr.
Yes,
Biswas.
that is why.
What is the basis of
No,
your
that is
claim
why.
that whether it's with
Yes,
32
yes.
or 52? It is
You
up to
cannot-
them.
If
Even
they can
below-
decide, my lord, how
But the second
if-
part of, Mr. Barua, the second part of the submission is that you have not started, the authorities have not started an acquisition proceeding.
Yes.
Is it correct?
That will be the step because the last instruction that is the stop from the competent authority land acquisition, my lord. That is
This
the-
should
that
be
is the-
acquired under which act?
It is the NS 58, 56 Act. That
No,
is
no, under which act?
National Highway Act
1956 Act.
My lord,
Then who'd be the acquiring authority?
Kala, competent authority land
Yes,
acquisition
who is
agency
appearing for
concerned
Kala?
agency of
Mr.
that particular
Sharma?
district.
Have you initiated a,
Lordship, no instruction.
no, others are similarly situated?
Hmm.
No, see, Mr. Vishwas case may differ only on certain facts, but the issue would be the common one.
Yes.
Whether you have started an acquisition proceeding. Have you started?
In item number 5, Lordship, we
Yes.
have filed our affidavit.
Yes. What have you stated?
Lordship, item
No,
number
please,
5, may I read, Lordship?
just in briefly, you can just
Lord.
indicate. Have
There
you
were
started?
certain encroachments were also there.
Hmm.
Accordingly, public notice 1722 was served upon the encroacher, Lord.
Yes.
Yes, Lord. The chief engineer PWR Sanmari Guwahati filed his letter to communicated for acquisition of land as per provision of the Assam Land Requisition and Acquisition in 1964. Hence, in compliance to the requirements of the acquiring authority, the acquisition of land has commenced under provisions of the State Act. Moreover, although the provisions of the Assam Land Requisition and Acquisition in 1964 are being followed for acquisition of the land, the appropriate provision of the right to fair compensation and transparency and land acquisition, rehabilitation and resettlement Act 2013 are being followed for giving the compensation, Lord. So acquisition procedure has already started. Till today, we have not received any proposal.
No, it has to be after completion of the process.
Yes, Lord. Yes.
Award has to be published, then you'll only get compensation.
Then,
But your primary contention that there is no acquisition proceeding
Till
does
today.
not appear to be correct.
Yes. Yes.
Because see, these are matters, though factual in nature, we have to go by the records. If the records indicate that acquisition proceeding, it's not a question of denial that you dispute.
Yes.
Whether it covers your area or not, that may be a disputed question. But initiation of the proceeding cannot be disputed once the authorities come up with a positive statement that we have indeed started the acquisition proceedings. So if that is there, one part of your grievance goes. Now the question is, how much area do you intend to acquire? He has somehow made a submission 32 feet, 52 feet. There may not be any basis.
Sure.
But are you, you must be aware, or you must be, you obviously will be knowing how much area would be requiring for the project.
But in item 5, Lordship, the affidavit is filed only relating to that item 5. I think it doesn't, as because certain encroachment are done by this writ petitioner in item number 5. Those are reflected in the affidavit individually, Lordship. The others, but acquisition procedure most as because the acquisition procedure they will not take for a particular plot.
Obviously, it's for the project.
Lord. But in other cases, Lordship, from 2 to 4, we are not getting any instructions. In 5, Lordship, we have filed our affidavit.
We'll do one thing.
Yes.
We'll fix a date after the Bihu vacation.
Fine.
You produce the records. In the meantime, if you want, you can also put on records the factual parts so far as the item numbers, other items are concerned, other than item number 5.
Sure.
I think then we can dispose of the
Yes.
matter. See,
If the record is produced, Lordship, yes, without
yes, few things are clear. The allegation that there is no acquisition proceeding, that does not appear to be correct. There is an acquisition proceeding. Number 2, it is factual aspect. How much land do you intend to acquire? And whether the allegation that land in excess of what you require has been sought to be included in the project, that part you need to just address. That's all. So those we can clarify. In whose petition? Three and 4 would be outside the purview of the acquisition proceeding. But are they encroachers? They are encroachers. Who are 3 and 4? No, who's the
Mr.
counsel?
Mr. Singh is appearing now, Lordship, his junior has just now.
Okay. Who was assisting Mr. Singh? Who was it, Mr. Singh? Nobody. Somebody had mentioned.
Yes, yes.
Okay, then we'll do one thing. We'll have a date after the
Yes.
Bihu vacation. No.
If
Third-
your Lordship reflects in the order the requirement, Lordship, so that we can
Okay,
There's the-
okay, yes. Third, the learned counsel for the parties. Full stop. It appears that in this bunch of cases, an affidavit in opposition has been filed in WPC 4921. Correct?
18235, item number 5, Lord.
5 is
No,
4921.
yes, Lordship, 4921.
4921 of 2022, in which it has been stated that an acquisition proceeding has been initiated by following the due process of law. Full stop. Para. তার আগত লিখিবা হা had the land council for the parties. Next লিখিবা. It is the contention on behalf of the petitioners that there is no valid acquisition proceedings and the land sought to be incorporated in the process otherwise exceeds the requirement. Full stop. That's what it will live. There is appears that full stop. On the other aspect of the requirement of land, comma, let instructions be obtained. Full stop. It also appears that in rest of the cases, comma, affidavit in opposition have not been filed. Full stop. Para. Accordingly, the matters are directed to be listed, adjourned, matters are adjourned and directed to be listed on 26th of April. Is it okay?
Yes, sir.
26th of April, 2024, by which time necessary instructions may be obtained and affidavit may be filed. Full stop. The relevant records may also be produced so that an endeavor may be made to dispose of these writ petitions as it involves a project of public importance.
Okay, so
And there is an interim order. Full stop.
I'm
Para.
afraid in item number 2.56, I think remain items NSA is not fit party. But-
There we have passed the general order, doesn't matter. Is there interim order in all the cases?
But who also it is successful, I have seen.
Interim order, if any, stands extended till the next date of listing. He has said only 5.
Lordship, he's for the revenue, Lord.
Acha,
District করছে নি? Lordship on. Oh,
এইটো হলে লিখিবা in few of the cases affidavit has been exchanged last কোনটো কেছত লিখিব নালাগে further affidavit in the meantime last there থাকিব এটা Okay.
My name is shown in put item. Fine.
if you want we can show the
No, my name-
reflect the names of all
No,
we have
sir.
not reflected names of any of the council
Particularly,
we cannot reflect your name only we'll
I-
reflect
I
the
don't
names of all
understand.
all,
Why
all.
at the time we are paying you were not-
all of you
For item number 2, see put up Friday, that's number 3.
Sovereign. We're fixing it on 26th. Let some further affidavits be exchanged, instructions be obtained.
On 29th, my lord, if it is possible.
It can be possible 29th,
9,
9th, Monday,
29 cannot be below that. 31st,
30, 30,
30.
30, 30.
Huh?
Tuesday. Tuesday will go for disposal,
Yes,
okay?
yes.
Okay.
So meanwhile, my lord, we will further file affidavit in.
We have already said,
Highly of that. Interim may kindly confirm.
well, continued, okay. Naam kita diba, ha? SK Singh, Jana to sir, then, ইয়াৰ চাই দিবা আৰু এইফালে H Sharma, additional senior advocate, R Pujari, revenue, তাৰপিছত N Bordoloi, C Borua, R Pujari. নালাগে আৰু হেৰি আৰু প্ৰথমতে ক'বা কি পঢ়ি দিয়াচোন কি কৈছে Hard so and so kori pare. Nahitu na hoga. Nahitu na likhiba. Affidavit has been exchanged from which it appears. Affidavits have been filed by the respondents from which it appears that land acquisition proceeding has indeed been executed. Sir. Then had to initiate it. Affidavit has been filed from which it appears that it has been initiated. Sir. Okay, hold it, sir. Hetu nala, hetu nala kiba. And further affidavit may be exchanged. Okay, forward. প্রথমতে ভাবিছিলো এটা এফিডেভিট দিছে এটা গম পাইছো সবতে ম্যাক্সিমামত দিছে এটা দুটত নাথাকিলে দি দিব সেইবিলাক না in few of the cases বুলি কৈছে yes next 6
My lord, the petitioner, they are the owners of a RCC building. And second floor was let out.
SBI who appears
SBI. There is no standing counsel.
Mr. M. Sharma, he normally appears. What is the matter about?
Matter is this, lordship, the second floor was let out by the predecessor interest of the petitioner, lordship, to the estate bank, where a Bunda branch is going on, lord. And lordship, all of it, huge amount is lying there in the bank account. The petitioner number 1 is the mother of the grandmother of the petitioner number 3. She is about 85 years. Petitioner number 2 is the wife of late Suman Talakar. And petitioner number 3 is the son who is the unemployed engineer, passed out from the engineering college only last year. And lordship, the bank issued a letter, lordship, putting the account, operation of the account on hold, that your lordship will get at page 85.
Okay, we'll issue notice.
Okay.
But don't you think that these are essentially disputes essentially of civil nature?
No, lordship, my prayer is only, lordship, because they are depositing the rent in the bank account of the petitioner number 3, but not allowing to withdraw, lordship. And further, the bank has requested the petitioner to renew the lease deed, which we are ready, we have given the letter, we are ready to execute the new lease after expiry of it.
No, aren't you asking for a declaration? In the garb of a writ petition.
No, holding of the account, lordship, it cannot be held on mere minor pretext or
No,
complaint lodged
it
by
it is not a freezing of account. Had it been a freezing of account, it's not a freezing of, we do not know what is going on.
Lordship, the petitioner, your lordship, will please to consider that petitioner, they are the owners of the premises.
No, that is your,
And bank is depositing per month.
that is the projected case. We do not know, but matter appears to be a dispute of civil nature. Okay, Hertford SP Roy Learned Counsel for the petitioners who are aggrieved by the action of the respondent bank in not allowing the petitioner to operate their account in which the rent and other charges are deposited by the respondent bank, which is a tenant under the petitioner. Full stop. Para. Let notice be issued, returnable on 1st of May 2024. Who is responsible? 3?
Lordship, she lodged a complaint claiming herself that That
This will be a civil matter.
no, for that civil suit is going on between the private respondent.
Issue notice returnable and so and so. Let shall be taken for service of notice upon the respondent by registered post with AD. Steps by tomorrow. Full stop para. This court has however noticed that the dispute appears to be one of civil nature. Full stop. Therefore, the maintainability. While notice is being issued, comma, the maintainability of the writ petition is however kept open. Yes, next. Yes.
But it is regarding supply of dietary articles.
Supply of?
I am an eligible contractor, my lord.
Just a minute. It on করা নাই, হ্যাঁ? Microphone to on করা নাই, তাহলে এবার এটা very good আছে। আছে না on? এটা on করা যায়। Yes, please.
But it is regarding dietary articles, supply of dietary.
In where?
The director of health services.
No, which place do you supply? Some hospital?
This is not, I am not supplying. I am a supplier. In 2021, NIT was issued centrally at directorate level of health service.
Okay.
But this was challenged by 3 petitions, and accordingly, the petitions were disposed of with a direction that the fresh tender should be issued.
Yes.
Your lordship will find the order at page 53 of that order.
Okay. Issue fresh tender.
Issue fresh tender.
Thereafter, fresh tender
Thereafter,
issued.
the director has issued a letter to the joint directors that the joint directors at the joint district level the tender should be issued. My humble submission before this honorable court that from annexure 11 to I, my lord, these are the letters from the joint directors.
Yes.
Joint directors, these are the letters from joint directors that they don't have any infrastructure regarding e-tender at the district level. And since a long back, my lord,
Yes.
some selected persons are supplying, my lord, without tender. For that reason, my lord, if the infrastructure are not available there, my lord, and then another, it will delay the matter, my lord, the tender process, and who will be affected, my lord?
You are intending bidders.
And
You are intending bidders,
yes, my lord.
aspirant to bid in the new process.
Yes, my lord.
But you said that there is no infrastructure in the
District level.
offices of the joint director
Joint
and the district offices.
Yes, sir.
So as to hold e-tender.
Yes, my lord.
Yes, sir,
I have
yes,
annexed the letters from
Yes,
joint.
Mr. Bora.
My lord, I will have to obtain instruction, but otherwise, my lord, it's an intergovernmental issue, my lord. If there is no infrastructure available, it will be made available, then tender process will be conducted, my lord.
But now, how are you doing it? How are you maintaining it now? That
My lord, probably with the.
when was the initial NIT? 2021.
Yes, my lord, that was stated by this honorable court.
Okay,
my lord.
that was interfered.
Yes, my lord.
Now 3 years have passed.
Yes,
How
my
are you running it?
with the probably with the contractor who were running earlier, my lord.
This is against the doctrine of fairness
Yes, my lord, I
and
understand, but there
fairness
was
and
a,
transparency, public distribution.
yes, my lord, there was a stay order by this honorable court, and that petition has been disposed of in the year 2023, my lord. So there are.
Now, the challenge which was upheld by this court in the 3 writ petitions, was there any direction to have the tender process in a decentralized manner?
My lord, it was the issuance by the department before the honorable court that
It is, my
they
lord,
will go for tender process, my lord.
No, that we have understood. Tender process going is fair enough.
Yes, my
But
lord.
was there any direction from this court to have it done in a decentralized manner, district-wise or joint director-wise?
No, my lord, there was
Then
no
what is the
direct-
difficulty in going for a tender process by the directorate office? Go for identify the different districts, they will bid, but the process will be done in the directorate office where infrastructure is there.
Very good. My lord, I will obtain instructions. Why they have taken this decision, I will have to obtain instruction, my lord. If they have taken the instruction that it will be done district-wise, my lord, there may be some reason also, my lord. And after all, it has to be done, my lord. I understand, my lord, in a public procurement system, the tender has to be done. So, my lord, whether it is done centrally or district-wise, my lord, it's up to the
See, it
department,
is
my lord.
only the process,
Yes, my lord.
whether the process is done in the central office or it is done district-wise.
Yes.
Doesn't matter.
Yes, my lord.
The
That is
process
my-
has to be done by
Yes,
following the prescription of law.
Yes, my lord. That is my contention,
Now,
my lord.
if what Mr. Chaudhary is contending, that the district offices or the joint director office do not have the expertise or infrastructure
My
to
lord,
have an e-tender process, go by the
Yes, my lord. In that case, they have all the facilities, all the infrastructure will be made available to the district officers.
But
Because my
when are you making it available?
My lord, I will have to obtain instruction. It is true that, my lord,
Part 3D Chaudhary Learned Counsel for the petitioner. Full stop. It is the contention of the petitioner that in the year 2021, a notice inviting tender, a tender process was initiated for supply of dietary items under the Directorate of Health Services. Full stop. The said process was, however, the subject matter of challenge in 3 numbers of writ petitions, which were disposed of by this court by directing issuance of a fresh initiation of a fresh tender process. Full stop. It is contended that pursuant thereto, communications were issued by the Director Health Services to the various joint directors Health Services to initiate tender process at the district level.
Yes.
Full stop. However, due to non-availability of the required infrastructure,
Yes.
the said process is yet to be initiated, as a result of which, the supplies are going on without following a
Yeah.
tender process. Full stop. Para. Let notice be issued, returnable on 29th of April 2024. Sri DP Bora, Learned Standing Council, Health Department accepts notice on behalf of all the 3 respondents. Extra copies by tomorrow. List on 29th for instructions.
Obliged, my lord.
The during pendency of the petition, the district at district level, as all the districts are not available, the infrastructure. So this may be stayed,
Staying of what?
staying the decision, by e-tender at district level, otherwise.
No, this stay will lead to confusion because the dietary items are of essential nature. Who will supply? Who will consider?
Yes,
Much.
obliged, my lord.
Meet lister.
Yes,
It is a matter of RTA Act.
Okay.
File of original application dated 25.
Have you, there is a standing council. Have you served?
No, I have not found out.
There is a standing council. You serve him. If there is urgency, we can have it tomorrow.
CIC, there is no statistical need for central information. I searched it, but I haven't found.
This is not against the state.
Not against it.
Okay. What about CGC? Will they appear?
CIC is not, standing council is not available.
No, CGC. Any
CGC does not.
Mr. Roy? Would you appear? It's for the Central Chief Information Commission.
Lodge by.
We can have it tomorrow if
Lodge.
there is urgency or
Lodge.
after the vacation. That's up to you,
After
after vacation, but serve him a copy.
Yes.
Heard Sri N.M. Hazarika, petitioner in person. Full stop. The respondents. The grievance is against the Central Information Commission. Full stop. Sri S. Roy, learned CGC, who is present in the court, has submitted that he would accept notice that he can appear for the said respondents. Full stop. Para. Let a copy of the petition be served upon him during the course of the day, and the matter be listed for motion immediately on reopening of the Bihu vacation. We could have taken at 2 o'clock, but 2 o'clock this court is not sitting. And tomorrow, item?
Lordship, please.
Yes.
Yes. In the year 1988, a land was given by the government to a Santha, which is Amguri Sansthir Artha Samik Unayan Arus Sanskriti Vikas Santha.
Where was it given? When? 1988.
A.
Land given
Yes, land was given.
to you.
Yes. I am not the Santha.
Okay.
I am the, I
To
am
an
one of the-
organization.
Yes, to the organization, which is called the Santha.
Okay.
Now, since 94, in 1994, there was a construction that happened of a 2-room, which was used for the benefit of the people coming from there, using it in a category of a bhavan. So the name was Amguri Bhavan. So people who used to come from Amguri district, who used to come here, use it for their benefit, whatever it's medical, education,
Prior to the allotment of the land.
in course of the allotment of the land, because the
No, you
allotment
said
happened in
allotment
88.
88
Right,
or not 98.
88,
Okay.
88.
After
88.
88. After
88.
the allotment, you had constructed 2 rooms.
Yes, so the allotment was there with the Santha for a long time. In 1994, 2 rooms were constructed. The construction purpose of the construction was that this will be used by the people when they come here for their benefit. Subsequently, in the year 2021, there was a settlement order passed in
21.
favor of the Santha.
Okay.
Yes, that settlement order, your lordships, is at page 49.
49.
49
Okay.
is annexure P1.
Mm.
The entire purpose of this was given at a very meager amount to the Santha for the benefit of the people. Ultimately, it is for the benefit of the people of Amguri, which is the Sibsagar district, in which people used to come and enjoy the benefit of this.
Okay.
2 days or 3 days after this settlement was passed, the organization converted the land, executed a development agreement, and the land was given away to certain private people for construction of commercial buildings on the same land by the Santha. So this is a development agreement by which a third-party right was created. Subsequently, construction happened. Certain people have bought flats in that. There were 2 buildings constructed. One was A, one was B. A, they said, was for the people of Amguri. B, they said, would be completely commercial. When this happened in 23, a suit was filed in the trial court. The suit is still pending. An injunction order was passed, subsequently vacated. We came in a first appeal, which is still pending before this court.
Mm.
Now, when we filed the suit, we came to know that this land, there was a restriction given by the government for 15 years. You cannot do away with anything with the land. We realized that when the agreement was executed, this was done away by the government. So the 2 orders that were passed, obviously we tried to apply for it. The orders we have not obtained these orders. We filed the application that we've gone before the government. Those 2 orders are not available with us. We've tried our level best. There was a cabinet decision given, and the cabinet decision subsequently converted into this policy of waiving of that right of 15 years. So that's a prohibitory order. So today I am before your lordships against those 2 orders, which has now completely changed the purpose and intent of the land. The people who were enjoying this land is now gone, because it has now gone to people who have built for commercial purpose.
Who are you?
I am a resident of Amguri. I am a senior reporter. I work for the benefit of the people. The entire intent of giving this land was for people like me. And the people
Where
who
do you
was,
reside?
sorry,
Where do you reside?
Sibsagar.
No, no, where in Sibsagar?
I have given my address, Your Lordship. That's at page
47.
4,
Affidavit.
4 and 5 also it's mentioned. And at page 11, I have explained who I am. Para 2.
No, no, how are you, don't you think that this has got involvement?
No, I am
of
challenging the
public
policy.
interest?
I am challenging the policy of the government by which this restriction was done away.
No, who are you to challenge?
So that's because the land ultimately was given
How are we
for,
affected? If at
I'll-
all,
I'll tell
it
you,
is
Lordship,
the-
why
it is
I'm
the
affected.
public.
I'll tell you, Lordship, why I'm affected.
Hmm.
It is just not me. The entire intent of the legislation at that point of time was that the land be given to for a particular purpose.
We are not raising any questions on the nature of the challenge. You can very well challenge, but we are on the forum where you are before today.
Yes.
From what you have submitted, it
Yeah.
appears that you are trying to raise a issue of public importance, where
I,
public is involved.
see, the suit that was filed, Your Lordship, in the trial court was also filed in a representative character. The suit was,
No,
the
suits-
representative character,
We are governed by a particular set of code. But
Under
in a writ
220
petition, if you come in 226
yes.
with a prayer of this kind, I think it should go before the PIL. We are not saying anything on merits, whether you have a right or not. But if you are raising this issue and two of you, you stay at Sibsagar, maybe you want to espouse the cause for the public, but do it in the proper manner.
Lordship must just remember that my entire intent is to challenge the policy decision of the government.
Policy decision,
I
yes.
am not on the,
Policy
on the
decision,
competence.
policy decision, you are not affected.
I am, Your Lordship.
No, it is the persons who may use that particular land.
So so
You are
that's the
espousing
entire,
you are espousing the cause of others.
so in fact, the entire purpose is that.
If you are not precluded from espousing, but do it in the proper manner.
So therefore, if I can use the land,
No,
I am directly affected.
do it in the proper manner. Withdraw this file up here, we'll give you liberty. Up to you, otherwise we'll pass orders. Heard. 3, RB Fukan. Learned counsel for the petitioners. Who, full stop. Also heard. Yes, what do you do?
Yes, sir.
Up to you.
We'll try our luck for in a PIL.
Okay, withdraw then. Okay.
I'll take a liberty.
Oh, we'll definitely grant. No, these matters we are not saying that we will not examine. We'll definitely examine. You're raising something which is appears to be important. Also heard Sri H. Sharma, learned additional senior advocate, and Miss G. Hazarika, learned standing counsel, Revenue Department. Full stop. On a brief hearing, this court is of the opinion that the issue which is sought to be raised by these two petitioners appears to be a cause which has been espoused for the public in general of Amguri, of Sibsagar district.
Of Sibsagar district.
Full stop. Tara. Ideally, such a cause of action is required to be espoused in the form of a PIL, public interest litigation. Full stop. At this stage, Sri Fukan, learned counsel for the petitioners, submits that he may be allowed to withdraw this writ petition with a liberty to file in the appropriate manner within bracket PIL. Full stop. Para. Writ petition accordingly stands dismissed with liberty as prayed for. Full stop. In case the petition is presented as a PIL, it is needless to state that it has to be done in accordance with the procedure prescribed.
Great. Wonderful. Extremely great.
Made please looking. Lordship, the petitioner are fair price shop owner, Lordship.
Fair price shopkeepers.
Lordship,
Yes, what is your problem?
problem is that there is a
Yes, what is your affidavit? Affidavit filed,
Not
instructions.
inspection receipt.
What does your instruction?
Only the page, the annex 9 page, only the PTC authority, only the right to direct code, requesting
Oh, director, yes, madam, director.
annex. Sir, 955.
23 matter, okay. We'll grant some time. Heard the learned counsel for the petitioners. Petitioner, one petitioner.
Lord petitioner.
Petitioners, what's the para? Sri Musahari, learned standing counsel BTC, submits that he has received certain instructions and the matter was also communicated to the director
Right.
of Food and Civil Supplies.
Right.
Food and Civil Supplies. Full stop, para. Miss S. Sharma, learned state counsel. However, submits that instructions are awaited and sometime may be granted. Full stop, para. Accordingly, the matter is adjourned to enable the learned state council to obtain necessary instructions. Full stop, para. List on 1st of May.
Lordship, kindly prepone Lordship, because these are priority sector thing. PDS is a priority sector.
Okay,
We are
then 26th of April. Madam, 26th April.
Lordship, there is interim order that
Interim, what is the interim order?
interim order not to discontinue us.
Interim order, pastor. If there is an interim order, what is the hurry?
Lordship, even then we are facing difficulties in distributing the items.
Why? We thought there is no interim order. Let her have adequate first May. Before having interim, why are you making inconsistent prayer? Interim order passed earlier to continue till the next day of listing. Yes.
Lordship, next item is also
Same issue.
Okay. Same. Okay. Okay. Will it cover the other case also? You go through the instructions, we'll have it on the next same date. Huh? How the learned counsel for the parties? Full stop. It appears that instructions have been received. Full stop. List on 1st of May along with so and so. No, 1st May. 1st May করে দিল এটা আগটো 1st May করে দিল interim order আছে না 26 1st May. List on 1st of May 2024 along with WPC so and so.
here is also an interim order that
Interim order passed earlier to continue till next date of listing.
obliged.
1st May দুইটা একেলগে সেইটো কিবা আছিলে না সেইটো সিরিয়ালি আহিলে হয় কিন্তু মানে 532 ওইটো আগত আহিব ন ওকে কিমান নম্বৰ এইটো 1394 532 লাগিব yes next day 13
Item 13.
Okay, item 13, I have received one settlement, it is not specific. But
what is the matter Mr. Singh?
My lord, there is tampering in the Jamabandi
whereby some area of land has been shown against a person, whereas that much of area doesn't exist in the entire Jamabanti.
Okay,
Kindly-
let him have the instructions then.
Right.
Heard Sri S.K. Singh, Learned Senior Counsel. Assisted by Sri A. Ganguly for the petitioner, full stop, para. Sri G. Hendrik, Learned State Counsel. However, submits that instructions are yet to be received. And he accordingly prays for some time, full stop, para. List, we fix a date,
Okay.
list on 1st of May.
On 30th, my lord, I have other matter.
Okay,
Before the-
30th May is a Tuesday.
30th April, my lord.
30th April is a Tuesday. You stay back on 30th, you'll have it on 1st. Okay, 30th of April.
Obliged.
Some concession to outstation council.
Highly obliged, my lord.
Literally outstation, not very far off.
Item 20, submiss.
I was just trying to leave that item 17, review matter. I was told that some matter will take long time.
Yes.
Review matter, that whether secretary has been appointed by the nominated.
Here
body.
some, I've been told that some DB order is there for
Yes.
day-to-day hearings.
My lord, what I pray, my lord, nominate advocate told me that he received the report today. Let him look into it, but your last review is pending. It can be taken up tomorrow.
Tomorrow, last day, we cannot say, we may fix it. We'll not know the list tomorrow.
We'll take a
Motion.
chance. I also don't like it, but
Okay, we'll try, we can try tomorrow, but we'll only try.
my
We
lord.
cannot assure. Mr. Mahmood, tomorrow, today there is some matter fixed,
Yes. So I think
and we had, it was mentioned in the morning, we said it after the, okay,
we'll try our luck tomorrow.
Okay.
We'll let him go through the record when
okay.
he said that he did. not-
Item number 17.
70.
17. Sri Ardhar, Learned State Council submits that records have been received just today, full stop, para. As urgency has been expressed by Sri Das, the Learned Senior Counsel for the applicant, comma, list for consideration tomorrow. We'll try, nothing more than that. Okay. Yes, Mr. Sarania,
My please, Lord, my lord, my senior learned-
is he there?
Yeah, my lord. My lord, prior to that, my lord, the IA 1058/2024 has been filed by the petitioner, my lord. There is an error in the cost title, my lord. In the respondent name, father's name wrongly spelled, my lord. I'm checking, my lord.
10.
1058.
Father's name of the respondent number 8.
Father's name is wrongly spelled.
Who is respondent number 8?
Janaklal Bosmotari.
Okay, that we can correct, that's not an issue. Who is appearing for the private respondent? Private respondent number 8, is anybody appearing?
He does, senior counsel.
Is he there? You are with him? Okay, we'll allow this,
From the state side, no objection.
just informal correction. Mr. Kursi will be appearing.
Please, my lords, I'm all set to assist your lordship.
It will be a pleasure to hear you. First, let us
Well,
dispose of this.
only- Please, my lords, please.
Okay. Heard. Sri S. Kursi, Learned Senior Counsel, who is present online and assisted by Sri M. Sarania, Learned Counsel for the applicant petitioner. First, by this application, a correction has been sought in the, while describing the name of the father of the respondent number 8. Full stop. It has been submitted that while, that in the writ petition, comma, by inadvertence, the name of the father of the respondent number 8 was stated to be late Lokhi Kanta Horonier, which is to be read as late Mrigendranath Basumutari. Full stop. Also heard Sri D. Sekya, the learned AG, Assam, assisted by Sri Gogoi, K. Gogoi, learned State Council. And Mr. Das, is he there or not? Is he there in the court otherwise? And Sri D. Das, learned Senior Council, assisted by N. Das, who do not object to the said prayer, full stop, para. I accordingly stands allowed by directing correction of the name of the father of the respondent number 8 as late Mrigendranath Basumatari instead of late Lokhi Kanta Sarani.
My lord.
Full stop. Registry is accordingly directed. No, the learned counsel for the applicant petitioner is accordingly directed to submit amended cost title in the main rate petition. Yes.
My lord, I have a small pair, my lord. Regarding another IA, I filed an application to impeach me as a party respondent.
Who are you?
I am, my lord, a contesting candidate in that Procedural constituency. Last time, my lord, I got second highest vote, my lord.
You are afraid of him?
I am not afraid of him. If he's my lord, now he's MP. He's MP, and his license goes, his my lord, caste certificate goes, my lord, that is my lord. I am the second highest, my lord.
You are of course not afraid, otherwise you would have not come to the court.
And in fact, my lord, that has been pointed out by me, my lord. Your lordship can see now he has been corrected in my petition, my lord. Because I have written that, my lord.
How are you affected?
My lord, it's a reserved constituency. It's for STP. So why should I contest with a person who is not ST, my lord? Is it not my right, my lord? I have to be right because I am.
See, he's what we have understood. He's made a challenge.
No, I am very much interested to outcome of this.
To a cause which only affects him.
My lord.
The after effect of the court's verdict,
my lord,
whether it affects you or somebody else, that is not our concern. Our concern is whether you are intrinsically connected with the dispute which you are trying to resolve.
My lord,
we do not think you have any right.
I am very much interested to come out with the result of this petition because your lordship can see.
It is in the realm of speculation. You may contest, he may contest. If he is declared as an STP, he will have a right to contest. If we hold otherwise, he may not. But how do you have a say in this list which has been raised by the petitioner?
No, my lord, your lordship.
You have to have some social interest. Yes, in this list. What will happen thereafter, we do not know.
All right, I'll satisfy you tomorrow, my lord. Your lordship kindly, but whether he has no objection, my lord.
See, implement application, we are very, very liberal, as you know.
My lord.
There is no problem in giving an opportunity of hearing, but at least you have to make a semblance of right.
My lord.
That your rights may be affected. What right?
My lord, I am
it is not even germinated. No rights have germinated. We have not even held him.
No, my lord. So your lordship kindly say I am a genuine candidate of the my lord that ST constituency of the Pukurazar.
Was his certificate cancelled on a complaint made by you?
No.
No.
The
answer is
no. That is no.
The person who has complained is a party here.
My lord.
He is take care of the rights who may be affected.
Even
how do you come in? Otherwise, Mr. Mohanto, no problem in hearing you or anybody.
No, my lord.
But as a matter of principle.
I am just submitting, my lord. Why I am interested,
as a matter of principle, why should we? We may not go.
My submission before your lordship, I am very much interested to, my lord, the outcome of the result of this case.
See, your role may not be even necessary. You have formidable colleagues on the side.
My lord, that's true, my lord. But I express my interest, my lord.
You watch the proceeding.
My lord.
Sit on the fence, watch the proceeding.
But I mean,
not now. Not now.
My lord, let it be tomorrow, my lord. Let him continue, my lord. I'll satisfy you.
See, we have been told that there is a DB order for day-to-day hearing, and there is some urgency. At least we have to give some attempt to honor.
No,
morning we have indicated.
My implement, my lord, will not hamper anything because I'll support the argument of the my lord government side, my lord. Definitely. So I will not make any hamper. I will not even. I am not going to argue.
Will you assure the court Will you assure the court that you will not make any arguments?
My lord, definitely, my argument will be, I'll support the area and other government council. So that is my.
See, this second half, this court is not
My
sitting.
lord.
Like, we have
No,
very
no,
less
I'm
time.
not wasting time.
That is
But-
why I have indicated, we have very less time, but still then, he has made
Probably
some
my lord, I have
request.
also no objection.
We
on
have
that,
tried
my
to, whatever is.
I have objection.
lord. Then you file objection. If you have objection, you file objection.
Because he never raised objection in the filing nomination paper that he's not willing to stand. So how now
No.
this can? after-
Yes, that time here, that my lord, his caste
In
certificate
19.
was cancelled. Because last time, my lord, I fight with him, my lord, person who is not SC, SD, my lord. And last time I am the second candidate, my lord. That's why I am submitting, my lord. Your lordship kindly, my lord, implead me, my lord. I am very much interested, my lord. Your lordship kindly see.
Your interest from the point of view of contesting is not an interest so far as implement application is concerned. Implement has to be in connection with the lease before us.
My lord.
You are not the complainant.
I'm not.
You are not an
That's
witness,
correct.
nothing, you are not connected. Only because you are contesting the elections, you may be interested in the proceedings.
My lord, I am
But
very much.
you
That's
cannot-
why, my lord.
You are not a necessary party at all. Interest, there's a vast difference between interested party, necessary party. Yeah, your participation will not affect, or non-participation will not affect the outcome of the proceedings. The adjudication process has to be fair by giving all the necessary parties an opportunity. We do not.
Let there be, I may be allowed to act as an intervener, my lord. That is up to your lord.
Intervening is a different aspect. You may find intervening.
No, I am giving rest assured that I am not going to any American.
Okay, let us
My lord.
start with the
My lord.
proceedings.
My
Where is the order of the Honorable Division Bench?
My lord.
Lords, the order is there. My learned friend will place that before your lordship.
Just a minute, please. There is some office note. It is an affidavit in reply as well. So, okay. What has happened thereafter on the next date? 5/4?
Well, Lords, then after that, the matter has not been taken up. So your lordships are now taking it up.
The
for the-
affidavit in opposition has been filed in the meantime by RA.
Yes, additional affidavit also.
Okay. Yes.
From the state side, I do not know about the private respondent. They wanted to
R8,
file.
R8, Mr. Das,
File, my lord. They have also.
file.
Private
Even
respondent also file.
Furnished copy?
Yes, sir. they have.
Okay.
আমার কথা বল।
Yes,
Lords,
Mr. Bassett, you can start.
I'm grateful, my lords, if your lordships will be good enough to look at paragraph 31 and 32 of the Honorable Division Bench's order. Your lordship-
31 and 32.
Paragraph 31 and 32 is just sums up, my lords, essentially the division bench. I must point this out to your lordships.
Yes.
Division bench
Yes.
is relying on essentially the issue
Yes, sir.
of natural justice.
Volume to बढ़ा पाएंगे। हाँ? हाँ, sir. हाँ, नहीं. Okay. Okay. Yeah. Can I request you to have the microphone slightly nearer you, Mr. Khurshid?
My lord, certainly. Your lordship will now be able to hear me clearly.
Now it's okay.
I'm grateful.
31 and 32.
31 and 32, my lords, is in the context of the learned bench having come to the conclusion that there is no violation of natural justice. That was one important point. And secondly, that the speaking order, the impugned order of the SLLC was a speaking order and sufficiently a speaking order. These 2 points that the Honorable Learned Bench came to.
Which paragraph are you referring to?
The findings, if your lordships will see.
31 is reads as in view of the above discussion.
That's right. So it's in view of the above discussion, they're essentially, except that they're saying, as certainly the Honorable Court would have said, that this is only for purposes of the appeal that came in an interim order. So
Right.
yeah, it's not a finding. Your lordships are familiar with this.
That we have seen. We make it clear that these observations would not have any bearing.
Quite right, quite right.
That we have seen.
Where is the paragraph? The paragraph on natural justice. Well, as your lordship will just give me 1 minute, I'll point out the relevant paragraph that lead to these observations in the end. If your lordships would be good enough to look at paragraph 25.
25.
23 onwards.
23 onwards.
23 onwards. We have considered the submissions advanced by learned counsel for parties and have perused the material available on record. As observed earlier, the learned single judge has recorded prima facie findings to the effect that the SLSC has not recorded reasons in its order dated 12/1/2024. The vigilance officer has not personally examined the respondent number 1, and the SLSC has not provided any opportunity to the respondent for adducing evidence. So those are the critical points that the learned bench came to a conclusion on. 25, my lords. So far as the question of recording reasons by SLSC is concerned, after perusal of the order dated 12/1/2024, we feel that SLSC has taken the consideration the report of the vigilance officer, the responses filed by the respondent number 1, the available documents, certificates, etc., submitted by the respondent number 1 and the complainant, as well as other materials available on record, which were placed reliance upon by the SLSC. It is another question as to whether the reliance placed by SLSC on the report of the vigilance officer or the documents, etc., produced by the parties in the written statement submitted by the respondent number 1 are in accordance with law or not. However, in our considered view, the order of SLSC at the first instance cannot be treated as a non-speaking order. So, non-speaking order, that's very critical. Then 26, my lords. So far as the question regarding personal examination of respondent number 1 by the vigilance officer is concerned, it is to be noted that the primary responsibility of the vigilance officer is to conduct a fact-finding inquiry and submit a report. If the finding of the facts projected in such a report remain unrebutted by the contestant, then in that event, it will be open for SLSC to form an opinion by taking cognizance of such report. After going through the paragraph 13.5 of Kumari Madhuri Patil, it can therefore be said that in every case, personal examination of the candidate or even the parents, guardians, or other relatives is not mandatory. It is only when there is no other incriminating evidence available before the vigilance officer, he should personally examine the candidate or the parent, guardian, or other relatives of the candidate. In a given case, if the vigilance officer is able to collect evidence which, as per his own assumption, is sufficient, he may or may not personally examine the candidate or other persons. So, my lords, these are two critical findings as far as the Honorable Division Bench is concerned. But if I may just underscore again, the Honorable Bench has said that this is for the purposes of interim relief. The sense that you would be able to contest an election based on interim relief was obviously a concern as far as the Honorable Court was concerned. And therefore, the court indicated that there should be day-to-day hearing and this matter should be disposed of. And we wanted it disposed of also, the writ disposed of. And so this direction was issued for day-to-day hearing. Now, my lords, for your lordships to be able to do this concisely and save time, I have prepared notes that run into about 10 pages, written submissions that run into 10 pages, because, my lords, ultimately, there are many issues that one can go into, but finally, we have to show to your lordships from Madhuri Patil, is there some departure from Madhuri Patil, paragraph 13, and 2, have
you furnished a copy to the other side?
Right.
Please do. Yes, you
my
can.
lords, and my lords,
Your colleague has handed over.
Yeah, I'm grateful. I'm very grateful. So the other point really is is Madhuri Patil in letter and spirit followed. Now, my lords, it may be my inadequacy that I couldn't persuade the division bench that Madhuri Patil in letter and spirit has been followed. There was, and I must say that I must caution your lordships in advance, we had given some judgments that come from places like Maharashtra, where there are also rules that have been put in place after Madhuri Patil. But the rules largely are the same as Madhuri Patil. There's no departure, no real additions, etc. But I might say that there is some clarification, and I point that out to your lordships. But the general principle is the general principle of what is required in natural justice, and that may be amplified in the rules, but it is not something that is an add-on or something that wasn't there. So, my lords, if your lordships will quickly be able to look at my written submissions, they're about 10 pages. Well, what has happened is that I have been, just to quickly bring your lordships up to date on this, that I got a certificate of Boro Kachari. My lord, there was attempt to create confusion that I was given a certificate of Saranya. I was given a certificate of Boro Kachari, and that certificate your lordships will find, your lordships will find at page 43, 2011, page 43 of the petition.
Yes.
So your lordship will see clearly, his name is given as Naba Kumar Saranya, but his certificate clearly is a certificate given for a Boro Kachari, if your lordships will see. The tribe is mentioned, and in front of that, Boro Kachari is mentioned, my lords. So the attempt to confuse the issue by saying that you were given a certificate as a Saranya, and that can't be given, and my lords, Milind and other judgments were cited. We are not contesting that. My lords, we are not contesting that Saranyas by themselves are not tribal people. But we are saying that Boro Kacharis who take Saran become Saranyas. In common parlance, they use the term Saranya to describe themselves, but they remain Boro Kachari. And this we have made very clear. They can change religion, but changing of religion does not take away their tribal attributes, and they remain tribals. Whether they take Saran or they become Christians, they remain tribals, my lords. That is very clear. There's no doubt there. So I just want to make clear that Boro Kachari is the issue. The issue is not Saranya. And my lords, the issue Saranya comes in, if I just may indicate to your lordships, the first certificate that was given by the Vigilance Committee, the first certificate indicated, although this certificate is given in 2018, the investigation report is given in 2018, the Boro Kachari certificate is given in 2011. But at the time when this certificate was given, apparently there was a notification that attempts made by Assam government repeatedly to ensure that Saranyas don't get left out of the tribal order. So there was a notification that Saranyas should also be given the certificates of being tribal. This notification was subsequently withdrawn. Where is it?
Where is the notification first?
Well, I just show that to your lordship, the notification in 1 minute. My lords, I'm sorry that notification is not in the writ. It's a notification dated 5th of June 2018. We'll place it before your lordships. But there is no dispute here. There was a notification, and that subsequently, and my learned friend, the Advocate General, said that we realized that was a mistake, so we withdrew that. Now, because it was withdrawn, an argument is drawn.
Withdrew by which notification?
Well, it was withdrawn by which notification? No, is this the withdrawal? Yes, this is the withdrawal one? Yes. Well, the withdrawal is 5th of June 2018.
So next day itself?
Next date?
No, you said the notification by which the state got said.
Well, I'll place these notifications before your lordships. So that they were in the writ appeal. They were not before your lordships. So I'll make sure that Mr. Saranya places them before your lordships. But there is no dispute here. There was a notification, and that notification was subsequently withdrawn.
Withdrawn.
But the argument taken from withdrawal of that notification is that you had got the status because of that notification, and that notification being withdrawn, your tribal status goes. This is the argument that was made. But I was given in 2012, the notification came in 2018 and then got withdrawn. I'll place those two before your lordship because they are in the writ appeal.
Are you trying to contend that irrespective of these notifications whereby Saranyas are tried to be included in the ST and the notification which was later withdrawn will have no impact on your status
It'll have
of
no
ST,
impact.
which was
It'll have
given prior in point of time,
That's right. I'm
declaring
grateful.
you to be a Boro Kachari. That is your submission.
I'm grateful to your lordship. We are Boro Kachari and we remain Boro Kachari. In 2011, we were given the certificate as Boro Kachari, and whatever may happen in the intermediate has not affected us at all. Not affected us, except to the limited extent. That when I argue that the first report is a first report, that first report, the vigilance officer relied on the notification.
Okay.
And that I admitted before the Honorable Single Judge, your lordship predecessor. I admitted before the Honorable Judge that I'm not relying on it because that's wrong. So the first thing is neither here nor there, the first report. I'm arguing, of course, my lords, that there are two reports. There is a first report, it has some consequences, and there is a second report which has some consequences. What I'm arguing is if the first report, my learned friend's argument is that the first report and the second report is a continuation of the first report. My argument is the first report, if it was found unsatisfactory as far as the SLSC was concerned, then there should have been a speaking order to say, please continue because this report is inadequate. You please continue. That could have been done. So no speaking order at that stage was made. It just has been tried to cover up by saying that the second report is actually a continuation of the first report. And my lords, I underscore an important point, that this is a case where there's a relied upon tribal certificate that has lasted for over 10 years, 2 terms of parliament. Now, when that is questioned, there has to be some speaking order to say there is reason to believe that this needs to be investigated. And if it's investigated, rightly or wrongly found to be correct, there again has to be a speaking order to say this is not sufficient, not adequate from the vigilance officer. We need further inquiry. And that inquiry, my lords, as your lordships have seen, affinity test and so on come there, etc. Although, as your lordship knows, affinity test has been treated by the Supreme Court not to be a litmus test of tribal character. But affinity test does help in many ways, presumably. But no affinity test also was done in this case. So there's only cursory reference to the sister, cursory reference to other people, but no affinity test specifically has been done. Your lordship will come back now to my note. So, my lord, your lordships have noted that I have said people who take saran become saranyas, and often they refer to themselves as saranyas. But that's because in common social parlance, they call themselves saranyas. But that's not when they talk about being tribals. When they speak about being tribals, then they obviously rely on their tribal attributes, etc. Your lordships will see in paragraph C of my written submissions, your lordships will see in paragraph C of my written submissions,
yes,
that I've, in the middle of that paragraph, further proselytization of tribal people of Assam, basically amongst Boro, Kachari, and Raba, both of whom are tribals, commenced from the coming of the Christian Baptist missionaries when tribal people accepted
you're
Christianity.
referring to paragraph C.
Paragraph C, my lords.
C, where do you have it?
Middle of paragraph C.
Exactly below B.
About 6.
Page 3.
Paragraph C.
Paragraph 3. This is page 3. Page 3.
Page 3. Okay, page 3.
Paragraph C. The C may be coming.
There's another paragraph C.
All right,
That
that
is
comes in. I'm grateful. So this is paragraph C on page 3,
Okay.
where I've mentioned that Christian Baptist missionaries, etc., etc.
Just further, which one, which line are you referring to?
Well, in paragraph C, if you come down 6 lines, if your lordship will come down 6 lines, where I've mentioned Bodo Kachari and Rabha,
Correct.
etc. And then we've said there are Christian Baptist missionaries, etc., and so on. And then Vaishnavite cults of Assam also that started proselytizing, and that therefore they gave what is known as Saran. And by receiving Saran, they became Saranyas. But that didn't change their tribal character, and calling them Saranyas didn't make them non-tribals. Now, my lords, very quickly, paragraph 3 at page 4. Although this is a collateral point, this is also an important point. I've mentioned, if your lordships will see 3 notifications: 11/5/2018,
Yes.
6/6/2019, and 5/9/2022. I've mentioned these, and then your lordships will see what Madhuri Patil requires, which I have mentioned. If your lordships will see, I'll bring your lordships to Madhuri Patil a little later. So Madhuri Patil, the 1994 judgment, because there's a modification in 1997, Madhuri Patil, paragraph 13.4, clearly lays down that there shall be 3 officers, namely additional and joint secretary or any officer higher in rank to the director of the department concerned, director social welfare, tribal backward class welfare, as the case may be, and in case of ST, a research officer who has intimate knowledge of identifying the tribes. A research officer, we thought the research officer was not there, but my learned friend has replied that the research officer is there. However, as your lordships will see a little bit later, there is no contribution as far as the research officer is concerned. Now, my lords, 13.5 of the Madhuri Patil, that was 13.4. 13.4 was about SLSC. 13.5 of Madhuri Patil, if you just go down a few lines,
yes,
that's about the vigilance cell. Each directorate shall constitute a vigilance cell consisting of senior deputy superintendent of police and such number of police inspectors to investigate into the social status claims. Now, my lords, very clearly, this is a senior police officer and then investigating officers, as many as required. Subsequently, my lords, these were converted into 3 separate vigilance cells because the work increased. So 3 separate vigilance cells were increased. Then, my lords, if you come to paragraph B on that very page, I've mentioned at page 48 of the writ petition, my lords.
yes.
Paragraph B, there is an impugned notification dated 11/5/2018. All the 3 notifications I have impugned. And these notifications, my lords, wherein the superintendent of police Assam has been nominated as a member of the SLSC. My lords, now your lordships will notice, he is supposed to be the person supervising the police investigation. He is the person who receives the report and passes it on to the directorate. And therefore, the
SP, Superintendent of Police?
superintendent of police. But here he has been
CID has been made CID has been made a member
of the scrutiny committee. Now, my lords, it can't be that he is receiving information as part of the vigilance cell and then placing it before scrutiny committee of which he is a member. Well, that would be a clear violation of Odi Alteram Partem.
Mr. Khurshid, just a clarification. You, in 13.5, you have said the directorate should constitute a vigilance cell, which the constitution of which has also been prescribed
In Madhuri Patil.
In Madhuri Patil. First is the senior deputy superintendent of police.
That's right.
Under him, such numbers of investigating officers who may be involved in making the investigation.
Quite right.
Here
Quite.
there is no direct role of the superintendent of police of CID.
Well, I can understand that.
Don't you think that it will be stretching too much, because since the superintendent of police, by virtue of his office, he also is a member of the SLAC.
But that is the issue. That's the issue.
He being the head of the
That the scrutiny committee does not have any police officers. The scrutiny committee is supposed to decide on the material that's provided by the police, whoever be the police officer. But if a police officer is placed in the scrutiny committee, that violates Madhuri Patil. Your lordships may just note it for the present. I will take your lordships to Madhuri Patil, and I will show from Madhuri Patil that this is the case. So this is just
the SLAC does not envisage that a police officer to be a part of it.
It doesn't. It doesn't. My lords, and that you find that your lordship will find that in paragraph A, in paragraph A here in paragraph 13.4, paragraph 13.4 of Madhuri Patil.
Yes, yes.
I'll bring your lordships to Madhuri Patil in a moment.
Okay, we have noted it. We have noted it.
Your lordship have noted it. If your lordship will now come to paragraph C. I'll bring your lordships to Madhuri Patil, but I've quoted the relevant portion here, and your lordships may just note it. Paragraph 13.5 of Madhuri Patil clearly states that the role of the inspector is to go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration, to the town and place from where he originally hailed from. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the parent or guardian, as the case may be. He should also examine the school records, birth certificates, if any. He should also examine the parent, guardian, or the candidate in relation to their caste, etc., and such other person who have knowledge of the social status of the candidate, and then submit a report to the directorate together with all particulars envisaged in the pro forma, in particular of the scheduled tribes relating to their peculiar anthropological and ethnological traits, deity, rituals, customs, mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste and tribes or tribal communities concerned, etc. Thus, the vigilance cell has to submit a report upon the investigation and make a record concluding remark or opinion, since it is meant for internal assistance to the scrutiny committee. Now, my lords, all this is important because the information of this nature has not been collected. If your lordship will take it from me, because I'll have to prove that this has not been collected. Ethnological and other anthropological material has not been collected. And if it is collected, my lords, if it is collected, it requires further scrutiny. It requires evidence to be placed. And I will then bring that argument as to why evidence becomes necessary in the level that is being applied across the board. Madhuri Patil was 1994, but now the Supreme Court and your lordships are applying across the board the duty to be fair. What is to be fair in circumstances which are similar to the serious adverse consequences about any decision? So, my lords, that is very important. My lords, I've mentioned Navneet Kaur and Harbhajan Singh. I'll bring your lordships to this as well. Navneet Kaur, there was some evidence and some cross-examination, but the Supreme Court finally said most people have been cross-examined. One person hasn't cross-examined, so we won't interfere in this matter. As your lordship knows, 136, Supreme Court often doesn't interfere. Then, my lords, This is a very small point. Sorry. So, my lords, I've made this point here at the bottom of paragraph C that having the same members or members from the same background in the vigilance cell and the scrutiny committee possibly leads to bias. In any case, the jurisdiction of the scrutiny committee is proscribed by Madhuri Patil, and there the police officers present is not provided. The police officers present. Now, your lordships may come to, if your lordship will come to paragraph E. Well, this point relates to what I said is the first report and the second report. If your lordship will keep it in the context of that. Paragraph 13.4 of Madhuri Patil states about the constitution of scrutiny committee. Paragraph 13.5 states that the constitution of vigilance cell, it also states about the functions of the inspector. Thus, paragraph 13.7 states, then paragraph 17 states, in course of the report is in favor of the candidate and found to be genuine and true, no further action need be taken except where the report or the particulars given are procured or found to be false or fraudulently obtained, and the latter event, the same procedure as is envisaged in paragraph 6 is to be followed. So here, my lords, I'm with candor, I'm admitting that there was a mistake obviously made as far as the first report is concerned. Mistake about the notification. Notification was given undue importance as far as the first report was concerned, and therefore that was wrong. There was no notification at that point of time to rely upon. In any case, 2011, when I got my certificate, there was no notification, etc. So all I urge is that if the issue of fraud or found to be false or fraudulently obtained is not there, then also I assume also that the scrutiny committee can ask for a further inquiry, but it must indicate so. Well, it must indicate. And if your lordship will only note, I will show that to your lordships, that the scrutiny committee has not committed to the vigilance cell at all to say that there is some more work for you to do. You haven't done a good job. You have to do some more work. And therefore, we are asking you to proceed, whether it's the first report or the second report, but we are asking you to proceed. Then, my lords, this question comes up, whether the second report, there is some confusion in my opposing side, whether the second report is a second report or it's a continuation of the first report. This is some confusion I need not dwell on this for too long, my lords. This is clearly there. And some details are given, my lords, in paragraph A of 4. Paragraph A of 4, I've given some indication that the same inspector had done the exercise, the first report and the second report. The same inspector had done the exercise, but the time the report was submitted, that inspector had been transferred. Whether that has a consequence at all or doesn't have a consequence, your lordships may keep that in mind. Then, my lords, paragraph C. Now, this is a judgment, again, my lords, of state of Maharashtra. And as I said, there's a caveat here that they do have rules, but there is nothing about the propositions here which is not generic. These are generic propositions, but there are rules also. So it may be possible to look further and see that these rules have created this situation, or that this is generic. And therefore, your lords, Adivasi Thakur Samaj Swarakshan Samiti, etc., etc. So there your lordships will see what I've quoted. Only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by the applicant, the case can be referred to the vigilance cell. While referring the case to vigilance cell, the scrutiny committee must record brief reasons for coming to the conclusion that it is not satisfied with the material produced by the applicant. Now, my lords, that's all that I'm underscoring, that the first report, after the first report, there had to be some speaking order to say, this is not sufficient, you need to inquire further, please inquire further, do the following things. but no such letter, no such direction, no such indication is there anywhere, and I'll show the record. So, my lords, what happens here is that the scrutiny committee is supposed to say something, have a speaking order to say we are not satisfied with the material or we are not satisfied with whatever is being produced, and therefore there should be a further inquiry or there should be a further investigation. This is not happen. This is not happen in our case, my lords. Then, my lords, the natural justice point comes in. My lords, paragraph 5. If I may just read this, my lords. In English law, natural justice is a term used for right to a hearing. It is duty to act fairly, which applies to every proceedings. Now, duty to act fairly, my lords, is a standard form in constitutional and administrative law in our country now, today. Possibly they started using this in England a lot earlier. But what we are saying is the duty to act fairly would require the right to adduce evidence and certainly to cross-examine evidence that may have been given. Now, this evidence that has been given has not been given on oath. This evidence has been collected by the vigilance officer and then produced on paper. Report is produced before the scrutiny committee. Now, is it correct? Is it subject to further questioning? Is it subject to cross-examination? Was the very critical question, and I lost on that point, that cross-examination is not necessary. But I will show, my lords, from Madhuri Patil itself, that adducing evidence, which would include cross-examination, adducing evidence is part of Madhuri Patil itself. I will just show that to your lordships in a moment. And my lords, this judgment that I've cited is Secretary of State for Home, Department, and AF and another, etc., etc. This is a House of Lords judgment, my lords. 2009 UK House of Lords 28.
Yes.
I'll just read that few lines that I have produced there. The best way of producing a fair trial is to ensure that a party to it has the fullest information of both the allegations that are made against him and the evidence relied upon the support of those allegations. Where the evidence is documentary, he should have access to the documents. Where the evidence consists of oral testimony, then he should be entitled to cross-examine the witnesses who gave that testimony and whose identities should be disclosed. Both our criminal and our civil proceedings set out to achieve these aims. Now, my lords, this is what I was hoping to be able to persuade your lordships, both the division bench and your lordship, that there is the duty to act fairly, because it is ultimately not between two private parties, but it's between a government agency and a government committee and a private party who is affected in a very dramatic way. Now, my lords, if I lose this case, if I am not able to persuade your lordships about my case, then after 10 years of being a successful member of parliament, I won't even be able to apply. And your lordships may kindly keep in mind that 19th is the last day for my filing of nomination papers. Your lordships have to take a break for the festival, and therefore I do realize that I'm placing a very heavy burden on your lordships. I'm sorry, but there will only be, and that's why I'm trying to do this as quickly as possible. My lords, tomorrow, maybe if your lordship will give me a little time, we will finish this tomorrow. As far as I'm concerned, it will all be done. No, look, my lords, if I may just...
We'll finish it today itself.
We'll finish it today. I'm grateful. I'm really grateful, my lords.
How much time Mr. AG will require?
Let him finish today, Lordship. Tomorrow I will finish.
Because today, second half with this
Yes,
court,
by today finish by 1 o'clock.
Okay.
Tomorrow I'll try to finish my part.
See, this way, that way, whatever we decide, we don't want to matter to be kept hanging. Parties should know the outcome of the litigation. When, if something can be acted. Otherwise, it will be infructuous. Entire attempt will be gone.
I am not available on 18th and 19th. That's why I will finish my part tomorrow.
We thought it would be over today. Tomorrow we could have delivered the judgment.
Will not be bad.
because it will not be possible to finish my part today.
We are also slightly handicapped. Second half,
Yes.
because of the Manipur
But
tribunal.
tomorrow I'll finish it.
Tomorrow, okay.
I'll finish it, Lord.
No, Mr. Khurshid, if you can
Let him finish today, Lord.
Yes.
I'll finish it today. There's no, as your lordship can see, I've created this written submissions just for this purpose, that all the relevant points can be placed before your lordships to
Yes.
reflect. Well, lords, then if your lordship will come to page 10, and this is paragraph 6. And my lords, this relates to the impugned order of the scrutiny committee, and that order is dated 12/1/2024.
Yes. Yes, please.
Yes, my lords, in a moment. So, my lords, whether it's the impugned order as placed before your lordships and before the honorable division bench was a speaking order is something on which I have amplified, and I hope that my inadequacy did not cause a problem. Here, my lords, your lordship will see there is a show cause notice that is issued, dated 11/3/2020. Now, essentially, the show cause notice reproduces whatever the Vigilance Committee has said. It basically reproduces the Vigilance Committee, whereas the Scrutiny Committee would need to work on the facts of the Vigilance Committee, and your lordships will find, Milind, your lordship will find the judgments are very clear that the scrutiny committee has to come to its own conclusions on the facts provided by the vigilance committee. The vigilance committee, Navneet Kaur, my lords, your lordship will just note Navneet Kaur, that the facts provided by the vigilance committee is not to comment, not to give its observations and suggestions. They just have to report facts. Scrutiny committee then draws conclusions from those facts. Now here, my lords, if your lordship will see 6, whether the order was a speaking order. My lords, I will read this in a little more detail because this is a critical core of my case. The show cause notice dated 11/3/2020 stated that Ajit Boro, president of APSU, gave a statement that the petitioner originally belongs to Kosh community. He became a Saranya after taking Saran. He stated that the Saranyas do not belong to STP category. He did not state that the petitioner is a Saranya Kachari. Now, my lords, there is no issue here at all. That I do not belong to any community other than Boro Kachari. There is no issue here at all. And I'm not insisting that Saranyas are tribals on their own, independently of being a surname. But lords, may I just say here that for my little understanding of Assamese culture, including the tribal culture, there are names that are interchangeably used. Kosh, Sarokosh, Deka, Das, etc. They are used interchangeably, but have nothing to do with the tribal nature. The tribal nature has to be investigated separately. The tribal nature has to be found separately. Now, here's somebody who says that he's a Kosh, he's not a Saranya. What is the verification that is done? What is the chance that I have of saying that he is saying this out of some animosity, etc.? My lords, nothing. If I don't have cross-examination, then I can't do that. Then, my lords, your lordship will see that I have noted here part of my reply dated 31/8/2020 that only Boros and Rabha people are Saranya surnames after taking Saran. There is no community called Saranya. It is also been noted at page 92 of the writ petition that Ajit Boro is not an elderly person from the locality to have knowledge about the village Diglipar. All the villagers in the said village are Boro Kachari. All the villages are Boro Kachari. Now, my lords, this can only be established properly by examination of the witnesses, by cross-examination of the witnesses, which has not been done. Then, if your lordship will come to paragraph B.
Just one line before that.
Just
one line. Whereas.
No, paragraph B here. In the show cause notice has been, where is the impugned order? Oh gosh. whereas the impugned order dated 12/1/2004 is silent about the same, silent about the community that dwells in that village, that they're all Bodo Kacharis. The order doesn't say anything about it. Then B, it has been stated in the show cause notice dated 11/3/2020 that scrutiny of admission register of Tamalpur Government NV School records that the name of the petitioner was written as Naba Kumar Deka in the year 1982. Now, Lord, I just said Deka, Das, Deka, these are all commonly used titles, but these titles do not distinguish a tribal from a non-tribal. These are generally used titles that are widely used. Then your lordship will see the whereas the impugned order dated 12/1/2024, it has only been stated that Navakumar Sarania used the title Deka as recorded in the admission register of the MV school for the year 1982. The said conclusion is without any reasoning whatsoever. It has been stated in the show cause notice of 11/3/2020 that the name of the father of the petitioner is stated as N.K. Lakhi Kanta Das, as his class was written as Assamese and subclass as Das in certificate issued by commanding officer of Assam Regimental Center, etc., etc., the certificate of discharge. Again, my lords, is commonly used surnames, titles, etc., which don't actually lead to a finding that you are not a tribal. Just as an affinity test cannot be a litmus test, then the mere name given to you as a generally in parlance amongst ordinary people, and these are names which are common names, and I'll show my lords, many of these names have commonly been used by MLAs and MPs from Assam who are tribals, who are from reserved seats. I will show that to your lordships in a moment. Then, my lords, what is happening?
And that it has been stated in the reply.
Then, my lords, at page 11, your lordship will see the third.
Point of time, Mr. Khurshid, your father, we are not too much swayed by the surnames used.
Please,
it can be Deka, it can be Saranya.
I'm
but
grateful.
We are to determine the status as a tribal.
Please, my lords.
So
Please,
was your father, who was in the army, I think, Assam regiment, was he ever treated as a ST?
my lords, this is what we have said, that this information has not been brought on record. This
you have to say that
my
your
lords,
father was also an ST.
my lords, my father was also an ST, and what has happened is my father passed away.
Have you stated that he was an ST? Because these status would be reflected in your service career, service book, or there may be some other.
My lords, unfortunately, I can't say that I've shown any evidence. Because
another question which we would have put to you, but since it has come, see, there is a school certificate of yours.
Yes.
Of 1982, which you have just read.
That's right. That's
paragraph B, 10, page 10, paragraph B.
Quite right.
This school certificate is of the year 1982.
Quite right.
Where you have been stated as Nabo Kumar Deka.
That's right, Deka.
No problem with Kumar Deka, no issue at all.
Quite right.
But the certificate was ultimately issued regarding your ST status in the year 2011.
In 2011.
That was the first occasion when you were declared as an ST.
Quite right. Quite right. STP.
Prior to that, do you have any characteristic? Because the certificate is only a recognition. If you're an ST, you're an ST in spite of having a certificate, but because of formalities, a certificate may be required, which you have.
Please.
There may be many person actually belonging to a tribal who do not have a certificate. In fact, they may not need it at any point of time because they are not seeking any advantage of that certificate. But you being a educated person,
quite
having
right,
studied, wasn't there any occasion for you to declare yourself to be an ST?
My lords,
2011.
My lords, curiously, this question was raised in my arguments. My lords, this question was raised because my sister gave evidence or gave a statement that she's a tribal. She's a tribal. My mother gave a statement that I don't have a certificate because we never needed a certificate at that time. We didn't need a certificate at that time. The sister
No,
obviously.
see, these are questions which had come up after this issue had evolved, questioning your status.
Quite right.
Are there any materials prior to 2011 which will substantiate your contention that irrespective of the certificate being issued in 2011, I was all along a tribal?
Well, I'll have to just check on this and take some instructions, because the whole arguments have gone completely away from what your lordships are asking as a fundamental question. They've gone just completely away from that, completely away from that. I was never said, and I will come to Madhuri Patil. I was never told that please show something prior to 2011. Show something of your sisters prior to 2011, etc. I was never told at any stage. If that had happened, and I think that's the reason why being told to produce evidence, adduce evidence becomes very important. Because now, of course, the argument is, my learned friend has argued on the other side, that you cannot adduce evidence. Now, if I can't adduce evidence, the kind of questions your lordships are putting to me, I should have anticipated those questions. But if I can't adduce evidence, I can't place them. I can only make statements. Quite right that that statement may not be enough, etc. Your lordship may want some clear evidence, etc. But my lords, I'll take instructions on this, and I will explain to your lordships at what stage, if at all, we had done something. Now, my lords,
are any of your relatives in having the benefit of being a tribal prior to 2011?
Well, I'll have to check. I'll have to check that.
Those would be conclusive kind of evidence.
Quite right. I'm grateful, my lords. I will check on that. I'll check on that, and I'll see how I can place that before your lordships.
When was this complaint raised regarding the authenticity of your
Well,
certificate?
the complaint was first raised in 2014, and then it was originally raised as part of the election petition, and the Supreme Court came to a conclusion that so long as the affidavit, so long as the certificate is there, you can't challenge it. Here, collaterally, you can't challenge it. Therefore, they withdrew those matters, etc. Then finally, in 2019. Now, of course, I'm not making too much of a point about 2019, 2024. This is supposed to be done within 20 days or whatever time, limited time, etc. I'm not making too much of a point there, because in between there was, people say that there was COVID and so on and so forth. So I'm not making too much of a point. Then my lords, in all fairness, I have to say, in E, again they say that you are a Sara coach. That you are a Sara coach, which do not fall under Boro Kachari. Sara coach does not fall under Boro Kachari. Well, I'm really, if your lordship will just permit me, I once saw Peter Sellers' film, my lords, and Peter Sellers went to a hotel, and he was standing next to a man who was next to a dog. And Peter Sellers says, "Does your dog bite?" And that man says, "No, doesn't bite." So Peter Sellers picks up the dog, and he gets mauled all over. And Peter Sellers then says, "How come you said your dog doesn't bite?" And this man says, "That's not my dog. My dog doesn't bite, but this is not my dog." So my lord, a lot of the questioning that I have dealt with, my lords, is about, does your dog bite? And I have to say that this is not my dog. I have to find my own dog, and I'll come back to you and I'll tell you this answer.
You may not have a dog at all.
I may not have a dog at all. Well, lords, I will take instructions specifically, so that whatever I say to your lordships is a verified and said. So, my lords, this in paragraph F, your lordships will come against you. Your lordships have sort of indicated to me. Well, as your lordships are again saying about the titles, etc. Lakhi Zaru coach, Deepika Zoru, name of Naba Kumar Sarania and Dilip Kumar Sarania has been included as Patidars. But subsequently, corrections have been made in their revenue documents, where they have removed those names like Lakhi Zaru coach and Deepika Zaru, etc. They've removed that. That must have been obviously done on the basis of knowledge that these people are all.
These corrections were done when?
Well, these corrections were done.
Started coming.
Well, these corrections were done in 2014.
Yes.
These
when the
corrections
complaints had come.
So they were done in 2014. partly because there was transmission of property to new generation, and partly because the names were wrongly recorded, and therefore they provided the correction. My lords, then your lordship will find in the other arguments the corrigendum about second and the first report. My lords, may I take your lordships now directly to Madhuri Patil?
Yes, please. আমার মাধুরী বাতুল লাগিব কপি এটা আছে নেকি দিছে নেকি দিছে না
13:4. Your lordships have Madhuri Patil?
Yes, please.
My lords, at paragraph 13, subparagraph 4.
The supplement. Yes, please.
Well, subparagraph 4, all state governments shall constitute a committee of 3 officers, namely an additional or joint secretary or any officer higher in rank of the director of the department concerned. 2, the director of social welfare, tribal welfare, backward class welfare, as the case may be. And 3, in the case of scheduled castes, another officer who has the intimate knowledge and verification and issuance of the social status certificates. In the case of scheduled tribes, the research officer who has intimate knowledge in identifying the tribal communities,
You have
parts.
indicated in your written arguments at page 4.
Yes,
That
well,
was right.
I've indicated.
Yes.
This is I've said is the collateral point, but there is no police officer in this. Well, this is very clear. There's no police
You
officer.
have argued that
I'm
the
grateful.
SLAC does not, as formed by the guidelines in Madhuri Patil, does not contemplate that there should be a police officer in the committee.
Quite right. Now, your lordship will come to paragraph 5. 13.5.
Yes.
Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claims.
Yes.
The inspector would go to the place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all facts of the social status claimed by the candidate or the parents of the candidate guardian, as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parent, guardian, or candidate in relation to their caste, etc., or such other persons who have knowledge of the social status of the candidate, and then submit a report to the director. So he should examine parent, guardian, or the candidate in relation to their caste, etc., or such other person who have knowledge of the social status of the candidate, with all particulars as envisaged in the pro forma, in particular, etc., etc. My lords, if your lordships will now come to, and I'm just reading this not in sequence, my lords, paragraph 7, I'm reading first because it makes the thematic purpose clear. If I may read 13.7 first.
Please.
In case the report is in favor of the candidate and found to be genuine and
That you have
true,
indicated. No further inquiries to
no further inquiry. And then, but 6 says how the inquiry is to be held. So
Yes.
your lordship will see 6, because this is where the adducing of evidence is called for.
Yes.
I will read that from the 4th or 5th line. The notice should indicate that the representation or reply, if any, would be made within 2 weeks from the date of the receipt of the notice, and in no case on request not more than 30 days from the date of the receipt of notice. In case the candidate seeks for an opportunity of hearing and claims an inquiry to be made in that behalf, the director, on receipt of such representation reply, shall convene the committee and the joint additional secretary as chairman, who shall give reasonable opportunity to the candidate, parent, guardian to adduce all evidence in support of their claim. My lords, with great respect, my lords, this is very clear. Adduce all evidence. And adducing evidence means, of course, that there will be cross-examination. The very nature of the inquiry becomes different, completely different, because it pinpoints exactly the relevant material that the scrutiny committee has to consider, and that would be based on this adducing of evidence and cross-examining, etc., etc. Then, my lords, the committee may, at the last three lines, the committee may make such inquiry as it deems expedient and consider the claims vis-a-vis the objections raised by the candidate or opponent and pass an appropriate order with brief reasons in support thereof. With great respect, my lord, this has not happened. This has not happened at all. So this may well be our inability to persuade your lordships as to what was necessary and what needed to be done. Well, I will now show to your lordships the impugned order passed by the scrutiny committee.
Yes, please.
So that will give your lordships idea, perspective from here, adducing of evidence, looking at everything, coming to a conclusion. If your lordships will have at page 111, annexure 27, 12th of January 2024.
Mr. Khurshid, just a clarification. In the procedure prescribed in subpara 6 of para 13 of Madhuri Patil.
Please, my lord.
Is the procedure to be adopted by the committee, isn't it?
That's right. That's right.
That if the director is in receipt of a report from the vigilance officer regarding doubts on the certificate, then he issues the so cause.
That's right.
Yes, please.
With permission, my lords, after the committee makes such inquiry as is deemed expedient, the director can't just simply take what has been given by the police and then issue a so-called notice.
Now, please let us again read 6.
I'm grateful, my lords. Shall I read the entire 6, my lords?
Please,
I think that may be useful. The director concerned on receipt of the report from the vigilance officer, if he found the claim from social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue show-cause notice supplying a copy of the report of the vigilance officer to the candidate by a registered post with acknowledgement due or through the head of the educational institution concerned in which the candidate is studying or employed. The notice should indicate that the representation or reply, if any, would be made within 2 weeks from the date of the receipt of the notice, and in no case can a request not more than of 30 days from the date of the receipt of notice. In case the candidate seeks for an opportunity of hearing and claims an inquiry to be made in that behalf, the director, on receipt of such representation or reply, shall convene the committee and the joint additional secretary as chairperson, who shall give reasonable opportunity to the candidate, parent, guardian to adduce all evidence in support of their claim. A public notice by beat of drum or any other convenient mode may be published in the village or locality, and if any reason or association opposes any person or association opposes such a claim, an opportunity to adduce evidence may be given to it after giving such opportunity either in person or through counsel. The committee may make such inquiry as it deems expedient and consider the claims vis-a-vis the objection raised by the candidate or opponent and pass an appropriate order with brief reasons in support thereof. Now, my lords, if I may just pinpoint the important fact is that an inquiry will have to be done by the committee itself. And my lords, what I have been at a disadvantage is that we've been told that you have appeared in person. We've appeared in person, my lords, I must make that clear. And you have given you've given your reply in writing. But when you appeared in person, you didn't ask to adduce evidence. You didn't ask to adduce evidence, and therefore evidence was not permitted to you. You have to ask to adduce evidence. My lords, with great respect, the duty to being fair, duty to be fair is now an overarching duty as far as administrative law is concerned, particularly where important subsequent adversarial or adverse consequences are going to come. There certainly a duty to be fair will require, and there is a word adducing all evidence, as Madhuri Patil provides for adducing all evidence. This is not provided by the rules that are made in Maharashtra and other places. This is provided in Madhuri Patil itself. It is provided in Madhuri Patil itself very clearly. Now, my lords, 2 or 3 points that I want to show, which is in the reply that I have filed. The reply that I,
Let us have a look at the impugned order.
impugned order.
The committee, first you had assailed the constitution of the committee.
So your lordship have that. That's independently of this. Now, of course, I don't want to be rude when I go to the committee. I can't say that you people don't have the power. You are wrong, etc.
No. So far as the constitution said, you have said the police officer is there.
Yes.
Let us see. Look at the committee.
So now, my lord, there is some problem with the committee. Now, your lordship will see the committee has the signatures.
Page.
My lords, the page is 115. 115. Now they've all signed as member of the state level scrutiny committee. And my lords, interestingly, no minutes are available of this day. My lords, even if a speaking order is made on this day, the minutes would have to record who all were present when this order was made. But there is no minutes of this meeting. So, my lords, I just take your lordship quickly through the speaking order. First, the narrative as to what happened in Vigilance Committee, made a request to inquire, etc., etc. Then your lordships come to page 112. Now, they admit here, my lords, that the CID in the meantime submitted their second report, White CID so-and-so, dated 4/3/2020. Now, this is a second report. Now, they are now claiming that this is not a second report. This is a continuation of the first report. Whereas on receipt of the second report from CID Assam, Vigilance Committee held a meeting on 14/9/2020 and decided to refer the case to the state level scrutiny committee. Whereas hearing the state level scrutiny committee was held on so-and-so, the committee heard Mr. Sarania, etc., which I've admitted to your lordship that I was heard. I was given a personal hearing. Whereas the Honorable Advocate General was asked something about the legal consequences of pending cases, and he was generously said that I can't say anything because they relate to legal matters. Then, my lords, if your lordship will come to just after the Learned Advocate General at 113.
Yes.
Whereas the SLSC examined in detail the findings of the Vigilance Committee, which were as follows. The STP certificate was issued in the name of Shri Naba Kumar Sarania, address so-and-so, as a Boro Kochari, signed by the Vice President and so on. The records obtained during the course of inquiry reveal that the parents and grandparents of Naba Kumar Sarania, late Lakhikant Sarania, used surname titles such as Sarakosh, Das, Deka, which are not listed under Boro Kachari. Of course, they are not listed, Malas. I have admitted that they are not listed. Srimati Deepika Sarania, sister of Naba Kumar Sarania, stated that she is an STP certificate and that she and her family belong to Sarania community, and her father used to write Das as his title surname. Now, my lords, she says I am STP, and there's no further inquiry. You are STP under which category, etc. No inquiry. Even a copy is not sought. Then, my lords, Shri Naba Kumar Sarania used the title Deka as recorded in the admission register, etc. In the certificate of discharge, the father issued by the commanding officer, the class of late Lakhikant Das, son of late Lekha Selaram Das, was written as Assamese and subclass as Das. So, my lords, there is no community called Sarakosh. It's perhaps used interchangeably with something else, but also there is no subclass known as Das. As I said, my lords, there are these titles that are used interchangeably, but there is no subclass known as Das. Then Raman Rabba, a parliament government, a permanent government, Gaon Bureau, etc., said that stated that Naba Sarania was born in so-and-so village. His father's name was late Lakha Das alias Sarakosh. The name of Naba Kumar Sarania's grandfather was late Sela Ramdas. Neighbor Sarania's family actually belongs to Kosh community, who became Sarania after religious Saran. So many issues here are correct. Many issues here are add-ons, etc. Who would find this except by inquiry? And then, my lords, and therefore the committee issues this notice to him. There's no application of mind. There is no analysis of all this. My lords, now if your lordship will just look at my reply, there are 2 or 3 very relevant points in my reply. My lord, this is at page 81. 87. I'm sorry, my lord, 87, annexure 21.
Annexure, page 87.
Page 87, annexure 21.
Page 87.
87,
Yes,
my
please.
lords.
Yes.
Now, I was told that you've never called yourself Boro Kachari. I've repeatedly said that I belong to the tribe of Boro Kachari. I've said that repeatedly. Now, if somebody required that to be investigated, they should have investigated. But it's only a question of not believing what I've said and believing what the others have said. And then, my lords, I have given all the reasons at paragraph 4. And that is at page 92. I've explained there's political rivalry. I've explained that the background of the person giving the statement, etc. And then on admission register also, I've said something. These were names that they were just placed in quite often in the voters list, and the names giving in the admission register, etc., are put down by whoever is gone with us, etc., etc. Well, lords, now there's an important couple of paragraphs that I want to show in this reply. Well, lords, at page 98.
Yes.
Page 98, your lordships will see I have given all the MLA constituencies from 1952 onwards, where surnames like Das, Deka, Das have been used, Patgiri, Ramdas.
Where in page 97?
98, Maloj, 98, page 98.
Okay.
98.
Okay.
So these are the same names that are used interchangeably here. And then just a few lines down from there, these are MLAs.
What is the relevance of this chart?
Well, the relevance of this chart is that these are all tribals. These are all tribals, and they have names like Das. They have names like Padgiri. So they're not necessarily to be pinpointed on what surname they are using or title they are using, as it's explained. And then, my lord, there are 3 MPs. On the next page, page 99, there are 3 MPs who two of them have put Boro at the end. We normally put Boro at the beginning. These are all.
Mr. Khurshid, we are very clear on this.
Yes,
the surname is not the determining factor.
I'm grateful, my lord.
Whether you write Das or Deka or Coach, that is not we are looking for. We are looking for your status as a STP.
Quite right.
Only because you write Sarania or Deka,
that would not matter.
You cannot be said that you do not belong to the STP. If otherwise you fulfill the criteria of being an STP.
Quite
We are
right.
on that, this point you can skip.
Yeah, my lord, I'll skip these points. I'll skip these points. Where are the changes in the revenue records? There's one last point that I will indicate, my lords, and then just 3 judgments quickly, 1 paragraph each. My lords, your lordship will come to annexure 14, page 66.
66.
Page 66. And it's actually at page 69. Your lordships asked me when the names were corrected in the revenue records, and I indicated they were in 2014. Whatever turns on this, Malaj, but the corrections were made in 2014, and they wouldn't be made if this hadn't been, if there wasn't some background to it, Malaj. Yeah. Now, Malaj, there are 2 points, 2 last points. If your lordships would, if your lordship will see the first report, annexure 12, that's at page 63. Your lordships have seen it, but I just want to bring it in sequence.
Now, how does this how will this have any relevance? The Jamabandi correction of Jamabandi?
No, no, Malaj, that point is over. Malaj, the correction of Jamabadi point is over. That point is over.
How will it have any relevance?
Malaj, the relevance is only to the extent that the name of Sara coach or the name of coach has been removed, and
No, it's not that. It is only a change of not the surnames. It is not a change of surname. It is the name of the person whose name will be recorded in the record of right of the land in question.
Quite right. But at least
69, as per Myadi number so and so application, and in accordance with circular officer report so and so, payment of premium done. In accordance with the Sitha circle officer so and so, in place of Patadar Deepika, the name of Naba and Naba Kumar Sarania, Dilip Sarania, father of so and so, has been included. It is only a change of ownership or change of name.
Your lordships may not trouble yourself with this.
Okay, because I don't think this will have any relevance in.
I'm grateful. Your lordship may not trouble your lordship with it. Now, there are just 2. There are just 2 points. One is annexure 13.
Page.
Annexure.
Page.
Of that. Annexure 13, page 65.
65, yes, please.
Your lordships have already seen the first report. Your lordships have seen the first report. That's the first report is at page 63. Page 110.
First report is at page 63.
Yes. 63. Yes, my lord. That's
63 is first.
If your lordship will come to page 65, my lord, one point that I had made that my learned friend was not able to show that if they are right about the first report and the second report, then there was to be a letter saying, please investigate this further. Now, there is no letter, please investigate this further. However, what has happened is, if your lordship will come to page 65, well, there was a parallel proceeding going on. The assembly wanted some report on the tribal status of Mr. Sarania. The assembly wanted some support by the letter of 25th 10/2019, annexure 13.
There was no need for caste certificate for army job, therefore there was no caste.
This is not in consonance with Madhuri Patil.
Well, this is separate from Madhuri Patil. This was an inquiry that the assembly had asked for some information.
Yes.
This can't be treated as part of the Madhuri Patil proceedings.
correct,
That's
correct.
all. I just want to show that. There was a report that was submitted. Some of this has now got into the Madhuri Patil report. But as I argue, this is not relevant to Madhuri Patil, and this cannot be taken into account. One way or the other, they may have some substance, some content, but this is not to be taken as part of Madhuri Patil, Malaj. That's so, Malaj, that is the case, Malaj. I was just told I have to report to your lordships about any prior to 2011, there was any tribal certificates, etc. As far as the father's case is concerned, in the army till 1962, there was no requirement of tribal certificates till 1962. But I'll give all this to your lordship before your lordship start the arguments tomorrow. I will put this on your lordships for your lordship's benefit. Well, now just quickly 2 or 3 judgments with the caveat, my lords, that there are rules that have been framed in these matters from Maharashtra. And if your lordships will look at page, well, my learned friend will hand out this judgment to you. This is not on record. Maharashtra Adivasi Thakur Jamaat Swarkhand Samiti. Well, my learned friend will
You
give.
have referred in your written submission.
I have,
It is
right.
referred.
This is to just show the judgment to you.
Yes.
And if your lordship will come to para 36. Malos, with the caveat that this is a proposition of generic nature, not affected by anything in the rules, but I had to fairly concede to your lordship that there are rules now based on Madhuri Patil. There are rules as well. In this judgment, your lordship, paragraph 36. Those are conclusions, but those are conclusions give a clear indication. Your lordships have paragraph 36A. This is the last page, page 50. Page 50.
Yes, we have.
Only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by the applicant, the case can be referred to vigilance cell. Now, my lords, I am pointing this out for the reason that I had indicated that there is no application of mine stating of reasons and then transferring the matter to the vigilance cell. This is what had happened in our case. So only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by the applicant, the case can be referred to vigilance cell. While referring the case to vigilance cell, the scrutiny committee must record brief reasons for coming to the conclusion that it is not satisfied with the material produced by the applicant. Only after a case is referred to the vigilance cell for making inquiry, an occasion for conduct of affinity tests will arise. B, for the reasons which are recorded, affinity tests cannot be conclusive either way. When an affinity test is conducted by the vigilance cell, the result of the test, along with all other material on record having probative value, will have to be taken into consideration by the scrutiny committee for deciding the case, validity, claim, etc., etc. So, my lords, this is a 3 honorable judges bench that have said this, but I've given.
The reference to the expression applicant in paragraph 36A is qua whom?
Well, in 36A,
in the third line.
Yes, the applicant
means
here,
whom?
here
Complainant.
the applicant here will be complainant. Then
Complainant.
No, it can't be. Malaj, I'm grateful. I'm very grateful. Malaj, it can't
So
be.
if we read in the context of the applicant being the complainant, only when the scrutiny committee, after holding an inquiry, is not satisfied with the material produced by the applicant,
Yes.
the case can be referred to the vigilance cell.
Quite right. Malaj, so it means that
when they were not satisfied that your complaint is not substantiated,
Quite
then
right.
the scrutiny committee may have the option of again remanding it back to the vigilance cell.
Quite right. Malaj, there's no issue there. The only thing that I'm insisting upon is that that there has to be a speaking order. There has to be a speaking order in either case. And I think for the complainant is just as necessary as it is for me. I have no complaints about the complainant using it. And my learned friend tells me, my lords, if your lordship go back to 36A.
Yes.
Yeah, that's the applicant. 36A, my lord, just if your lordship will keep that in mind.
Yes.
Is not satisfied with material produced by the applicant. So there's no issue here. That's the applicant would be the complainant. The complainant must produce some evidence, must give some material, and the committee will then make a speaking order and then refer the matter to the vigilance. I have no problem with that, because if there is a speaking order, then I get warned. At the earliest, I get warned. So for both sides, fairness would require that there should be a speaking order. Now, which other judgment? Now, my lords, if your lordships will look at page, my lords, that my learned friend will place before you, 2021 9 SCC 811. This is J. Chitra versus District Collector. Para 10, my lords. If I may just read this to your lordships, para 10, in the instant.
Just a minute, let it be passed on. Yes, please, paragraph 10.
Paragraph 10, my lords.
2021 9 SCC.
9 SCC, my lords.
811.
That's right, my lords. Para 10.
Yes, please. Yes.
In the instant case, an inquiry was conducted by the district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 1999 has not been challenged in any forum. The recognition of the community certificate issued in favor of the appellant by the district vigilance committee having become final, the state level scrutiny committee did not have jurisdiction to reopen the matter and remand for fresh consideration of the district level vigilance committee. The guidelines issued dated 12/9/2007 do not permit the state level scrutiny committee to reopen the cases which have become final. The purpose of verification of caste certificates by scrutiny committee is to avoid false and bogus claims. Repeated inquiries for verification of caste certificates would be detrimental to the members of the scheduled castes and scheduled tribes. Reopening of inquiry into caste certificates can be only in case they are vitiated by fraud and when they are issued without proper inquiry. So, my lords, this is only obliquely in my favor, that where something is closed, there, of course, it won't be reopened. But the very purpose of reopening, my lords, is something that I have said needs to be carefully studied, and that there has to be some speaking order that pertains to this. The my lords, one last judgment my learned friend will give to you. This is Civil Appeal number 2741 to 2743 of 2024. Most recent. I've already mentioned, my lord, Navneet Kaur, I've already mentioned in my written submission, but I need to place it before your lordships. And if your lordship may just note the paragraph.
I think this is the latest one.
This is the latest one, my lord. This is the latest. If your lordship will see para 12. Your lordship may just note para 12. The exercise that is to be done by scrutiny committee.
Paragraph 12.
Paragraph 12, my lords. Fifth line onwards, the power to deal with verification has been specifically vested with the scrutiny committee, and it falls within the exclusive domain of it in view of rules so on. So I've added the caveat, my lord, that there is a rule involved, but this is a generic nature of proposition. For the purposes of verification, scrutiny committee has to have all powers of civil court while trying a civil suit, and it can further take internal assistance of vigilance cell for verification in those cases as and when needed by the committee. So, my lords, that's where the evidence will be required. That's very important, where evidence will be required. That's it. And then, in addition to this, paragraph 14, my lords. You've said everything.
Yes.
So, my lords, your lordships have asked me about if we have any knowledge or any information about tribal certificates or tribal status in the family, etc. I will, whatever I have, I'll place before your lordships. But my proposition relating to that is that, my lords, if that is to be established, it is important to adduce evidence. And then I will be cross-examined and I will cross-examine them. That's very important. Only then it'll become clear. Otherwise, all this is done in a huff and done in a hurry. Well, it's just at the end, if I'm not holding your lordship back, well, it's the speaking order passed by the scrutiny committee. Very quickly, in 1 minute, if I can just show that your lordships. I just showed that to your lordships. I'm just reiterating this. Is essentially they have recorded what somebody said, and then they've mentioned Madhuri Patil as to how these procedures have to be followed. And they then at page 114, all that is recorded by the Vigilance Committee is reproduced. There is no analysis at all. And then, my lords, having reproduced it in 4 lines, thereafter, it is said that Mr. Naba Kumar Saranya does not belong to the Boro Kachari community. Well, with greatest respect, this is not a speaking order. Just taking what somebody has said, putting it down, and then saying that therefore you are not Boro Kachari is something that, my lords, is not a speaking order. Understand, well, this, my learned friend will confirm it to you, that when I was given a personal hearing, there were only 2 members. Not the quorum of 3. Altogether, there are 5 members. Quorum is of 3, but there were only 2 members. And there are no minutes available of this, my lords.
Where have you stated?
Page 13, my lords. In my written submissions, page 13, paragraph D.
In the writ petition.
Well, in the writ petition, your lordship will find this at page 271.
Page 27.
271. Page 271.
271.
Well, this is affidavit, rejoinder affidavit at page 271. Minutes of the Vigilance Committee are not kept in the department.
271, which paragraph?
Para 27, Mullahs.
No, there are separate. This not be 271. It is your affidavit.
What is the rejoinder affidavit? Our rejoinder affidavit.
Yes, it will be slightly different. Just reply. It will be 250, I think. Your rejoinder to whom? Respond number 2. Respond number 2.
Respond number 2.
Starts from 250. There's some difference in pages. Which paragraph, Mr. Khurshid? Can you?
27. Paragraph 27.
27. Okay.
Please, Mullahs.
No, where you have made a statement that Your personal hearing was by a committee of 2 members. Where is that statement?
Just find that. My lord, your lordship will give me a minute. My lord, my learned friend tells me it's para 8.
Of the additional reply affidavit, rejoinder affidavit,
That's right, my lords.
paragraph 8. Let me check.
Two people.
Yes. Present secretary, then SP, and only one member.
No, there are 3 members.
There are 3 seats. It says
3 members.
3 members, but there is one CID. I will already given my objection to the presence of a police officer.
Okay. Okay.
I'm deeply grateful, my lords, for putting so much pressure on you to give all the time. Thank you, my lords.
It's always a pleasure listening. Hearing.
Grateful.
Okay,
Grateful.
yes, can we have, we don't have the time probably. Mr. Das, you have come, you are for the complainant. You are for the complainant. Okay. But tomorrow, because of the situation involved, tomorrow we have to complete. Otherwise, entire exercise will become infructuous. So whichever way we decide, we have to decide. Let the petitioner or
We
the.
have to place the case in proper perspective. I was expecting that they will lay the complete text, which was not placed. So I'll have to take that time, but I'll try to please. It is not that I'm.
No, Mr. Advocate
But
General,
only
the urgency will not in any way come in your way of placing on the entire. We'll have your time.
That is what
Whatever, if you are arguing a relevant aspect, why should we stop you?
Absolutely.
And same thing applies for Mr. Khurshid, Mr. Das. But because of the exceptional circumstance, we are trying to make it very precise, short. And you can also prepare a written note, which Mr. Khurshid has done. That will help us.
Yes. That.
No, it's been
No,
given.
right now.
It's been given.
Right now.
We have already indicated. Senior council has indicated that will be given. Tomorrow is the first item, but tomorrow we don't want to. This is the last day of the vacation. Motions will be there. Mr. Khurshid, we are in a very difficult catch-22 situation. Tomorrow is the last date before vacation.
I
There
do
are a
understand.
number of extra requests for motion, and we can't say no to a
There is
motion.
a motion there for last 5 days.
Even yesterday, today, tomorrow are all declared motion days. Motion, as you know, are new matters.
That's right. New matters that come in. That's right.
And people expect that the matters should be taken up motion. We have also allowed, but we'll try to have it as soon as possible, immediately
Please.
after the motion.
Lord.
I think your rejoinder will also be necessary because we have just had a cursory glance of the latest case. The Honorable Supreme Court has dealt with the powers of the High Court to make whether a High Court can make a roving inquiry on a fact-finding committee.
That's right. That's right. Those are there. I think, my lord, there won't be necessary.
There is no evidence of any gross perversity. Those are the expressions. We just had a look. Perversity
My line of argument.
or any bias alleged. Perceptible bias. There is no bias in this petition. I think those hurdles, I think you still need to overcome tomorrow in your rejoinder. Well, let us hear the Advocate General tomorrow and Senior Counsel Mr. Das, then we'll come back to you.
Thank you. Thank you, my lords.
And tomorrow, immediately after the motion. Rest of the matters today, second half, we have a tribunal. So
Item 14, the interim order is still today.
14.
14.
Okay. 14 interim
There
order.
is some urgency, I'll give it.
He'll give dates. For urgent matters, he'll give dates, otherwise, normally.
Okay.